as a technical perspective. And because child sexual abuse is, of course, a very serious crime that has long life consequences for the victims. And this is why this has always been a priority for the European Union, and the European Union has taken several actions in the fight against sexual child abuse online. First, there was a framework decision that has been replaced by a directive in 2011, and that contained several criminal offenses in order to harmonize the legislation of the different member states. And back then, in the directive of 2011, there was already a legal provision to block illegal content online containing child pornography, or to ensure the removal of that content. So today, the fight against child pornography is still a priority of the European Union. Last year, the European Union has adopted a new strategy, and the main focus now is to require online service providers to detect illegal content and oblige them to report that content to public authorities. But of course, this has some major implications for fundamental rights, such as the right to freedom of expression, but also the right to privacy and data protection. And that is why we today we have invited Dr. Brendan van Alsenoy to enlighten us on this topic. Dr. Brendan van Alsenoy is Deputy Head of Unit Policy and Consultation at the European Data Protection Supervisor. He has previously worked as a legal advisor at the Belgian Data Protection Authority and also as a legal researcher at CIF. And he has worked also with a focus on data protection and privacy, intermediary liability, and trust services. He has numerous publications, one of which being the impressive handbook on data protection law in the European Union. I would like to thank you for your presentation today, Dr. Brendan van Alsenoy, and the floor is yours now.
Thank you very much, Sophie, for the kind introduction and also for the invitation. I'm delighted to be allowed to contribute to this series of seminars, and I'm especially delighted to be here because of the interdisciplinary nature of this seminar series, and I'm happy to quote unquote see a number of familiar faces amongst the participants. So I'm looking forward to an interesting discussion. So I'm going to talk today about the relationship between two very important policy objectives, namely the fight against child sexual abuse online and the protection of confidentiality of communications. And so by the end of my talk, I hope to have convinced you that the relationship between both these objectives raises fundamental questions regarding three themes. The first is the rule of law, the second is governance, and the third concerns the role of technology. So these three themes are kind of going to be, recurring throughout my talk and perhaps also in the discussion that will follow. But first, let's take a moment to step back and to see why these questions are coming up now in particular. So since December 2020, the European Electronic Communications Code came into effect, the recast Electronic Communications Code. And this has expanded the scope of the rules that apply to electronic communication services. And one of the reasons why the European legislator decided to expand the notions of what constitutes an electronic communication services was to include functionally equivalent online services in order to ensure that the rights of individuals were equally protected, and of course also to apply to ensure a more level playing field between operators of these services. And so one of the results of this extended scope is that certain services which were previously not covered, which are referred to as interpersonal number-independent communication services. So practically speaking, this means services such as web-based email, messaging services, or voice over IP services would fall within the scope of the electronic communications framework, which also includes, as many of you are aware, the ePrivacy Directive of 2002. So this change, is significant for many reasons. It even caused certain companies to temporarily remove some functionalities in their offerings in the EU. And it does also have an impact as to what we're going to be discussing today, which is the identification or the analysis of communications, private communications, with a view of identifying potential instances of illegal activity. So Sophie already mentioned it in her introduction. The Commission has been looking at this issue for quite some time already, and in July of this year issued a new communication outlining the European Union's strategy for the effective fight against child sexual abuse online. And so one of the main issues identified in this communication is that because of the extended scope of the European Electronic Communications Code, certain service providers would be prevented from continuing to carry out certain voluntary measures that they have been doing in the past with a view of detecting, removing, and reporting instances of child sexual abuse online. And so a classic example of such a service or such a technique is photo DNA. This is an image matching technology developed by Microsoft, which is used by many companies, in fact, in order to find and remove instances of child sexual abuse online. So basically what it does is it analyzes certain types of user-generated content against a database of unique fingerprints or hashes of known instances of child sexual abuse. And so photo DNA does not only look for material which is completely identical in size and format, but it's actually also able to identify relevant images, even if the image in question has been resized or otherwise altered. In case of a match, basically what Microsoft will do is suspend the account, but it will also file a report with the US National Center for Missing and Exploited Children. So photo DNA has already been around for a long time, and as I mentioned, it's used by a large number of organizations. But the technologies used to combat child sexual abuse online are not necessarily limited to known instances of child sexual abuse. So in case of photo DNA, there's a match against a database which contains those fingerprints of instances that have been confirmed as child sexual abuse. But there are also other techniques being used. For example, the use of the analysis of content of communication for certain keywords with a view of identifying potential instances of grooming. And we'll get back to that in a little while during the talk. But so in its communication, the Commission basically outlined a two-phased approach. The first leg was basically to make sure that the voluntary measures, which would otherwise, quote unquote, lack a legal basis as of December 2020, would still be able to continue. And to do that, what the Commission did was to propose a temporary derogation of the rules regarding confidentiality and the processing of metadata under the ePrivacy Directive. And as Sophie also mentioned, there's also a long-term perspective here, which is not just looking at providing a derogation for certain voluntary initiatives, but also actually the idea of making certain types of detection and removal mandatory. So Sophie also briefly mentioned during her introduction that this is not something which the Commission is starting afresh, but it actually has already a long-standing policy being developed, and the Child Sexual Abuse Directive is an important example of that. In this directive, you will find instances of certain types of conduct which member states are required to ensure are illegal. And this concerns, in particular, the intentionally knowing obtaining access by means of ICT to child pornography, distribution or dissemination or transmission of child pornography, or offering or supplying or making available child pornography. And there are indeed provisions also linked to the ensuring the prompt removal of web pages or the potential blocking of access to such web pages. But there isn't anything in this directive which specifically deals with the analysis of otherwise private communication. So not content which is uploaded to a web page for multiple people to access it, but really one-on-one communications between private individuals. So as a result of this initiative, this temporary derogation, the European Data Protection Supervisor was, of course, consulted, and we issued an opinion on this in November of this year. And so basically, what I would like to do is to kind of focus on the main points of this recommendation and how it links to some of those questions, those themes that I mentioned at the beginning of my talk. So I mentioned in the beginning that one of the main questions raised by the proposal concerns the rule of law. And I think it's important to underline that the Commission proposal raises questions which are not specific to the fight against child sexual abuse online, but in a way, these questions apply or come up with any initiative aiming at collaboration between the private sector and law enforcement, and particularly where they're going to undertake analysis of personal data with the view of identifying potential instances of unlawful activity. And so even voluntary measures by private companies can constitute an interference with the right to freedom or the right to confidentiality of communications and data protection. And so needless to say, combating child sexual abuse clearly amounts to an objective of general interest, which is recognized by Article 52 of the Charter, and also seeks to protect the rights and freedoms of others. But in accordance with the Charter, interference with confidentiality of communication is possible, but only under certain conditions. And these conditions are that they are provided by law, respect the essence of the rights, and comply with the principles of necessity and proportionality. From a legal perspective, it's of course it's not really relevant that the practices which the derogations sought to cover were already practices which were undertaken at a particular moment in time. So basically, in the run-up to December 2020, these types of activities were governed entirely by the General Data Protection Framework, by the GDPR. But as of December, a lot of these services which the derogation seeks to cover became part of the electronic communications framework, and therefore also subject to the protections of confidentiality and processing of metadata that's provided by the ePrivacy Directive. So for me, this raises questions both in terms of rule of law, in terms of governance. It's kind of a question of to what extent private actors should decide to freely or voluntarily decide to monitor certain types of illicit activities, and what are the legal framework? What is the legal framework that should be accompanying it? So, as EDPS, we questioned the purely voluntary nature of some of these initiatives, not only because there's a need for clear and harmonized rules, but also in light of certain positive obligations that the EU legislator may be said to have in light of its obligations under the Charter. So let's take a look at some of the specific points that we try to highlight as being particularly important in our opinion. So the first is kind of directly related to this question of lawfulness and what is the legal basis of the processing. So the proposal of the Commission did not explicitly indicate whether it's actually trying to provide a legal basis for the processing. It concerns a derogation, and so the question is that, okay, even if it were to be let's say carved out of the provisions which would otherwise govern these electronic communications as per the Privacy Directive, it would obviously still need to comply with the general data protection framework. And one of the requirements under the GDPR is to ensure that every processing of personal data has a lawful basis. And then the question comes up, to what extent could the voluntary activities undertaken by private parties, under which lawful basis would they be able to rely? And so we understand from the Commission that the aim is not to provide a legal basis as such, that there would still be a requirement to comply with Article 6, but we invite them to make this more explicit and to also identify which legal basis would be relevant. A bit more substantive, I would say, is the point that we make in the opinion regarding necessity and proportionality. So, as many of you are probably aware, there's been a lot of recent developments in case law of the CGU, not in the least with regards to Article 15 of the Privacy Directive, which basically allows member states to introduce certain derogations, provided it's done for certain objectives, and again, meets these requirements of lawfulness and necessity and proportionality. And so one of the things that made our job, and I think, policymakers' jobs in general, so also for the European Parliament and for the European Council, was the absence of an impact assessment. So normally, if there is a legislative initiative which is going to have a particular impact on fundamental rights, these would be documented and analyzed by way of an impact assessment. But there was no impact assessment due to the stated urgency of the matter, which was accompanying the proposal. So what we did is we tried to look at, based on the proposal itself, what are elements of interference which are there, and what are relevant considerations or safeguards that should be put in place. And so, as we also outlined in our own guidelines on assessing proportionality, there are a number of factors to take into account, such as the scope of the measure, the extent of the measure, what are the types of information collected, for how long, which categories of data are the people who are being targeted, or whose personal data are being processed. Are those, very likely to be already, let's say, quote unquote, suspects, or is there a high probability of also analyzing or processing data of people who are not? What's the level of intrusiveness? What's the margin of error? And these are all relevant considerations, which I think also come up in relation to this legislative file. And to kind of, give you a bit of a spoiler, on the whole, the EDPS, in its opinion, saw a way forward in order to try to balance these competing objectives: the fight against child sexual abuse online and the protection of confidentiality of communications, by adding additional further safeguards. The only noteworthy exception, or let's say the only red line that we identified, in our opinion, concerns the automated analysis of keywords with a view of identifying potential instances of child sexual abuse. For us, there's a real qualitative difference between, on the one hand, trying to match content of communications against previously confirmed instances, which have been reported, which have been documented, for which there should be an appropriate, governance mechanism in place to make sure that information is managed correctly, securely, and on the other hand, doing automated analysis on potentially unlimited set of users or communications with the view of identifying potential illicit activity. And so basically, in our opinion, EDPS took the view that the general indiscriminate and automated analysis of all text-based communications through these types of services with the view of identifying potential new infringements does not respect the principle of necessity and proportionality. Even if that technology is somehow tailored towards relevant key indicators, we still feel that general indiscriminate analysis would be would be excessive. So there were also a number of other points which, let's say, go more to the safeguards and also providing greater legal certainty. So our first question concerns the scope of the derogation. It's supposed to cover number independent electronic communication service, but this covers a lot of different services. As I mentioned, you have webmail, you have chat, but you also have, for example, have voice over IP. So the question was to be more specific as to whether which types of services exactly would be covered by the derogation. The types of detection measures could be spelled out more clearly in our view, and there's also a question mark regarding the reference that the Commission makes with regards to well-established technologies. So on the one hand, I think this tries to make sure that the derogation in a way remains limited and does not involve uses of, let's say, technologies which are likely to have high error rates and things like this. But on the other hand, it also raises the question of, like, okay, what happens if the state of the art and, let's say, privacy enhancing technologies evolves and there's new ways of identifying instances of child sexual abuse in a way which would be less intrusive. So we pointed out the need to give some reflection there. And then there's compliance with classic data protection principles such as purpose specification and storage limitation. What are the types of data that you're going to collect, retain, for how long? What's the data that's going to be reported, to whom? And there's a reference to other relevant public authorities. We think there's definitely a need to be more concrete and specific there. And also, what is going to be the review process that's going to be applied? Is there always going to be a human in the loop? When would it be triggered? These are important considerations. In the proposal and also in the positions that the European Council and European Parliament have formed, there is this question of what is the role of relevant authorities, in particular data protection authorities. And so the question there is how do we balance, let's say, the need for legal certainty and having an appropriate legal framework, and the ability for DPAs to exercise their role in providing additional guidance, and in certain instances also doing a prior consultation. So the GDPR provides for certain high-risk, high-impact processing activities to be a requirement of a prior data protection impact assessment. And in some instances, there's also a requirement of prior consultation. So going back to this question of the rule of law, one of the points that we felt strongly about making is that regulatory guidance as such cannot be a substitute for compliance with the principle of legality. So I made a bit of a jump there, so I'm just going to go back. I mentioned, the question of, which relevant authorities, what's the confirmation process, but also who is overseeing these databases, or also to, these technologies which are being used to make sure that they remain least intrusive. And what about potential restrictions of certain provisions of the GDPR, such as those that relate to transparency and data subject rights? Because of course, then Article 23(2) of the GDPR, which contains some additional conditions, needs to be taken into account. And we did feel that there was more that could be done in terms of already embedding in this derogation certain provisions which address those elements of potential delayed notification or information to data subjects, and we pointed to the recently adopted proposal for regulation on terrorist content, just by way of a source of inspiration rather than saying that was necessarily the right way forward. And so finally, the proposed derogation is expected to have a duration of no more than 2 years, unless, of course, the legislative process is concluded in the long-term legislation beforehand, and in which case that long-term legislation would substitute the proposed temporary derogation. But given the absence of a real impact assessment, and given the lack of safeguards, we considered that the derogation should not exceed the period of 2 years rather than 5 years as contained in the proposal. So basically, our view was that indeed there is a way forward for many of the objectives envisaged by the Commission by that proposal. We had one red line which relates to the indiscriminate analysis of content of communications. But one thing I think it's important to keep in mind, and we didn't get into it in our opinion because the proposal didn't address the specific issue yet, is the question of technological tools to protect confidentiality of communications. And in particular, I'm thinking here about the role of encryption. I think it's only a matter of question, and I mean the Commission has also outlined this, that they are going to be engaging with experts to look for ways in which the content of communications can be analyzed in a way that still preserves confidentiality or other properties that cryptography or encryption may be able to able to provide. But it seems that this initiative has to be seen in the context of a much broader debate also regarding the role of encryption and what its impact may be on legitimate law enforcement initiatives, and whether there are ways to reconcile these two competing needs. So I just included a screenshot of some of, let's say, the statements which have been made of in this specific area, which I think illustrate that this is actually something which is going to come back and is very much going to be a part of the discussion also when considering the long-term legislation, which is expected to provide mandatory detection and analysis. It's also come up, I think the Council recently adopted a document or a resolution concerning security with encryption and security despite encryption. So just to kind of show how different the viewpoints may be, and I think the question will be to what extent can the different interests be reconciled. So that's basically it for me in terms of an initial presentation. I apologize if I went on for a little bit long, but I'm happy to take any questions that you may have and discuss with you further. So thanks a lot.
Thank you, Brandon. That was very enlightening. And I will take the liberty to ask some questions first. But yeah, to the people listening, you can open your mic afterwards and ask a question yourself, or you can put it in the chat, and then I will be happy to read it